Hello, this is Matt on the Moon Lambeau channel. A non-Ripple attorney is advising the SEC to just give up their case against Ripple. And look, not that I actually think that the SEC is just going to be like, oh yeah, we're wrong, we'll walk away. Like, they're not going to just straight up give up. What they're going to do, if they want to go that route, is they're going to settle. So that would be them capitulating. I'd be perfectly fine with that. Don't be surprised in the least if we do actually ultimately see this. And so I've got this article from Law 360 titled, SEC Should Drop Litigation Over Ripple's XRP Token. Good to see that headline. Now, of course, the headline needs to be corrected because it's not Ripple's XRP unless you're talking about that XRP which Ripple holds, and that is not what is being discussed here. It's not as if the XRP token. In fact, that sounds like that basically flies in the face of reality. Like if that were the case, that would actually help the SEC. Like, that's basically the case the SEC is making. So now that I'm reading this, it's kind of funny looking at that and be like, as great as this article is, written by J.W. Verrett, if I'm saying that name right, as great as this is, gotta fix that part. You definitely gotta fix that part. I didn't even catch it the first time. I thought about it. I was like, oh yeah, the same mistake everybody makes. But now I'm just thinking, in particular with this article, that's like the worst place to make that particular mistake. Also, attorney John Deaton, he shared this along with Crypto Law, which is the group that he put together. Their website is crypto-law.us. You should check them out. Just a wealth of knowledge there. And you can find them on Twitter at cryptolawus. But John Deaton wrote the following about this. At this point, they can do one of two things. Number one, start talking settlement with Ripple, or two, dig your heels in deeper and fight even harder. Of course, by now, they really have a good idea what those documents and emails regarding Bitcoin, Ethereum, and XRP say that must be turned over. Yeah, and so there was a motion that declared, and it was reaffirmed very recently, actually, by Judge Sarah Netburn, that the SEC must divulge all their documents. Well, there are exceptions, actually, but they must divulge their documents, which will highlight how they came to determine the status of Bitcoin, Ethereum, and XRP to be commodities, securities, whatever the case may be. Which I don't think is going to go well for them, frankly. Because, even if they have good reason for why Bitcoin and Ethereum are what they are, you're going to find, I think, that XRP will fall into the framework of what they already said. So I don't think it's good for them, but we shall see. Anyway, check out this article, though. Excuse me. In litigation settings, it often pays to heed the advice contained in Kenny Rogers' classic song, The Gambler. You've got to know when to hold 'em, know when to fold 'em. This is useful advice for the U.S. Securities and Exchange Commission's ongoing litigation against the creators of the cryptocurrency XRP at Ripple Labs Inc. And so that's the part that really needs to correct right there. XRP existed before Ripple, and so his legal analysis spot on, but this is a fact that is missed by so many people. It's also not easy to go up if you want to, if you don't know, if you're not, especially if you're not particularly familiar with crypto, it's like, where do you even go to verify that? So I get it, people don't know it, they wouldn't even think to check it. And also, even if, at this point though, I'll say, even if Ripple had created XRP, it's so sufficiently decentralized at this point. I mean, yeah, you'd have a stronger case that Ripple made a boo-boo, and maybe they're going to have to pay some fines because they sold XRP as an unregistered security. But today, it doesn't matter because it's so sufficiently decentralized. You can't argue that it is in and of itself, by its nature, a security. I think that's true of pretty much all crypto. It can change from centralized to decentralized and vice versa. That's important to understand. But anyway, the piece continues. The SEC alleges that XRP is a security, and its sellers were required to file formal initial public offering documents with the SEC and abide by the heavily regulated IPO process, and that failure to do so 8 years ago and ongoing trading in the security violates the securities laws. The SEC needs to fold them on the litigation against Ripple and instead focus its energy on a formal rulemaking process to update the rules for securities registration to account for the unique dynamics of digital assets. Yes, and so right here, the unique dynamics of digital assets not accounted for. And frankly, if the SEC were being just, ethical, and fair, they would recognize that even if even if they believe now that it's the case that that XRP and especially the way they want to rule forward. If it's the case that the way XRP ended up hitting the markets, if that within a future framework would have been considered a securities offering, that's fine if you want to consider that. But you then don't retroactively go back and then punish them for rules that didn't exist. And so if you were being just, ethical, and fair, SEC, what you would do is just grandfather them into all of this. That would be the right thing to do, not sue them, and then just provide clarity for the entire space. But that's not what they're doing. Anyway, the piece continues. The SEC lost a number of pretrial motions in the last few months. A pretrial hearing before a magistrate judge demonstrated a pattern over 8 years in which confusing guidance from regulators and speeches left XRP holders, Ripple, and trading platforms completely in the dark with respect to the SEC's view of whether XRP is a security. This wasn't just a game of gotcha. It was a game of gotcha after an 8-year waiting game in which XRP's investment base grew exponentially. Fortunately, U.S. Magistrate Judge Sarah Netburn, who is overseeing the discovery in the U.S. District Court for the Southern District of New York litigation, refused to give the SEC blind deference in the face of this apparent lack of regulatory due process. In a victory for Ripple, attorney John Deaton was granted a motion by the court to file a request to intervene. If ultimately successful, he will bring the perspective of investors who have been harmed, not by the defendant, but by the SEC's actions, to the litigation. In another victory for Ripple and Ripple executives, Judge Netburn appeared to indicate the XRP has a utility function which undermines key aspects of the test for determining whether it is a security established by the U.S. Supreme Court's 1946 decision in SEC v. W.J. Howie Co. The primary victory for Ripple was that the judge granted the plaintiff's request for discovery concerning the SEC's internal deliberations about whether XRP should be considered a security. The defendant will have an opportunity to see how the SEC determined that Ether was not a security, as former SEC Corporate Finance Director Bill Hinman determined in a widely covered speech, but XRP is a security. While these discussions will be helpful to Ripple's defense and are a step toward due process in this specific case, I worry that airing these internal communications may affect the SEC's ability to engage in an honest internal dialogue over the regulation of digital assets in the future. These communications may also be used to challenge any future compromise at the agency over the regulation of digital assets. Tell you what, SEC guys, if that's the case, you did it to yourself, didn't you, son? Now you done messed up. Piece continues. This argues in favor of the SEC settling or withdrawing the action against Ripple and Ripple executives and preserve its range of options to draw up a new test in the future for the definition of a security in the digital asset space. So pause and think about that, guys. If this individual is correct, the way that he's interpreting the actual situation, if this is going to be a hindrance to them in terms of how they can rule and litigate moving forward, if that sufficiently matters to them, that's just one more reason for them to be like, okay, let's throw in the towel, let's settle. And they're not going to drop the case. They need to say, because they do need to save face. And I just realized that was a nice rhyme right there. Hit a thumbs up if you like that sweet rhyme. But that, if you're the SEC and you do want to save face, what do? All right? To me, it seems perfectly logical and rational. And look, they're not going to win on the merits. I don't think, anyway. Anyway, he continues here in this piece, though. Indeed, if the SEC loses the case, those pushing for a more accommodative definition to facilitate offerings like Ripple will gain momentum that the current leadership at the SEC may come to regret. While supporters of accommodative policy to digital assets can hope for a full victory in the case, that's one heck of a gamble that would impact the future of this next generation mode of capital formation. Better that the SEC withdraw this action and that all 5 commissioners work together toward a compromise that builds a definition of security required to register with the SEC that accounts for the unique attributes of digital assets. One key component of an updated test would recognize that digital assets evolve in a way that may meet the definition of a security early in its development while still centralized, but not meet the test later in its evolution as the digital asset becomes more decentralized. Now, guys, listen, if you've been listening to me for a long time, I've been running this channel about 2.5 years now. I've been saying that the whole time. I've absolutely been saying that the whole damn time. And more recently, you've seen SEC Commissioner Hester Peirce, who's very crypto-friendly, effectively saying the same thing. She's actually proposed a crypto safe harbor rule, which would account for this. It would literally account for just this fact that there is centralization early on, and then you'll have, whether it's 3 or 5 years, whatever it is, to get the cryptocurrency to a point where it's sufficiently decentralized. Otherwise, you gotta stop doing what you're doing, right? Safe harbor. That's a start. Maybe it's good. Maybe the parameters set for it are right. Maybe they could be adjusted a little bit, but the concept is correct. That makes all the sense in the world to me. Anyway, the public policy implications of the SEC's stance, which involves a suit against a cryptocurrency that has been openly held for 8 years with no action by the SEC, and large asset owners' losses precipitated by the SEC's filing of an enforcement action itself, are also dubious. You got to think, don't you think, did the SEC, were they that? Yeah, they probably were. They probably were that oblivious. They thought that they could just do whatever they want, ultimate rulers, and they thought nobody would question the terrible optics of this and the questioning of filing when against Ripple when they did all of this. Jay Clayton, his last full days when this happened. After 8 freaking years, of course people are going to be like, what in the ever-loving hell are you talking about, SEC asshats? Of course they're going to respond like that. Anyway, they wrap up by stating the following. Former SEC Commissioner Joseph Grunfest is rumored to have written to then chair... It's not a rumor. Well, it happened. Yeah, I mean, in fact, I've covered that in the specifics, actually. Written to then Chairman Jay Clayton with the admonition that no prior SEC enforcement action has caused as much damage to investors. Now, that is true. That did happen. This all suggests that it's time for the SEC to heed Kenny Rogers' advice. The SEC should fold them in the case against Ripple and instead open up negotiations among the 5 commissioners to refine the definition of a security in the digital asset space. That would be a different card game altogether, and one in which the incoming leadership at the SEC would hold a much better hand. Well written, bravo, round of applause, my friend. How about that? So you let me know in the comment section below what you think is going to happen. I still think that there's a pretty reasonable chance that you are going to see some sort of settlement in the not too distant future, especially if this is just going to be too damning for the SEC and if it could potentially take power away from them in terms of policy setting and future litigation. But I'll wrap up there. I am not a financial advisor. Do not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.